Welcome everyone to our webinar on protecting and enforcing your brand. By way of introduction, my name is Sahil Verma and I'm a practice leader in LegalVision's trademarks and IP team. Before we begin, a couple of quick housekeeping items for you all. After the webinar, you'll receive the recording and the slides in your email. Please submit any questions that you have during this webinar in the Q&A box and we'll answer them at the end. And last but not least, please complete the feedback survey after the webinar. Hopefully I've done a good enough job to get a 10 out of 10 from you lovely people, but if not, I'd greatly appreciate some feedback anyway. Also, just for your reference, for the next 48 hours, you are eligible for a complimentary consultation with our legal team. So to claim that, please just leave your contact details in the survey that appears when the webinar ends today. So, as mentioned, today we'll be discussing how to protect and enforce your brand. But before we dive into protection and enforcement, the first step in the process is to create a good brand, because without a good brand, you'll struggle to protect and enforce it anyway. So, what makes a good brand? Brands are signs that businesses use to identify themselves in the marketplace. Sorry, I'll just click next slide there. Brands are signs that businesses use to identify themselves in the marketplace. Signs that are distinctive have a higher chance of being recognized and identified by consumers. As such, owners of unique signs can more easily monopolize their brand in the marketplace by ensuring that all of their consumers are going to the one right source. Yes, brand names should be relevant and to an extent elusive to a business's goods and services, so that a brand is more easily found in online marketplace and etc. But brand names should not directly describe the goods and services being sold. So for example, the cleaning professionals. A good brand shouldn't directly describe the quality, quantity, kind, or characteristics of a particular business's goods and services. Whilst there are some benefits to descriptive brand names because consumers are likely to search descriptive words when trying to find goods and services online, these brand names will struggle to be registered as trademarks, which I'll touch on a little later in this webinar, and will often share the marketplace with other descriptive brand names. You may find, for example, if you call yourselves the cleaning professionals, there are going to be a bunch of other brands or businesses in the marketplace online that are called cleaning professionals or the cleaning professional, etc. You'll struggle to essentially monopolize that particular brand because of that market share. And obviously this will result in a split customer base. Now, the key to creating a well-established brand is by developing distinctive signs, such as a name or a logo, investing in trademark registration for that distinctive sign, and then monitoring the marketplace for copycats and taking swift action against those copycats to avoid brand duplication, dilution, and infringement. The rest of this webinar will focus on how to achieve this. So, what is a trademark? Another way of looking at signs or brands is by considering them as trademarks themselves. Now, trademarks as a concept are heavily misconceived in the UK. Trademarks themselves are not achievements or registrations or awards. Trademarks are actually just the signs that traders use on a day-to-day basis to distinguish their goods and services in the marketplace. So if I create a brand, I've created a trademark. I don't actually need to do anything. I have a trademark by way of creating it, as long as that brand is capable of distinguishing my business in the marketplace. So for that reason, in law, there exist two types of trademarks: unregistered trademarks and registered trademarks. If I create a brand name, but I don't register it with the UK Intellectual Property Office, then I have an unregistered trademark, and my rights in my brand will be significantly limited. So although trademarks can be used unregistered, which a lot of businesses in the UK do on a day-to-day basis, there are major benefits to registering my trademark. So why register a trademark? Registration provides a trader with the exclusive right to use or authorize the use of a particular trademark or sign or brand. This means that a registered owner has exclusivity in the UK to use their trademark for the goods and services listed within their registration. Registration also allows an owner to enforce their rights against other traders who are using confusingly similar trademarks for the same or similar goods and services. An action taken on this basis is called trademark infringement. Without a trademark registration, businesses will find they need to rely on other areas of law, such as passing off, to enforce their rights against copycats. Now, we are often approached by clients who have come across a business using a similar name to them for similar goods and services, and it's causing confusion in the marketplace. But they're unable to rely on trademark law to assert their rights because they haven't undergone that process of registration. Worse than that, sometimes our clients discover that the copycat has actually registered their trademark instead. Now, in these instances, it can be incredibly difficult and costly for the original owner to take those registered trademark rights away from the copycat. And in extreme cases, the other business's registered trademark rights might actually trump the original business's unregistered rights, forcing the original business to rebrand. So put simply, registration gives you the right to use your brand, and without it, someone else can take that right away from you. You really should be registering your trademark almost immediately. What is the registration process then? So brand owners must apply for trademark registration to the UK Intellectual Property Office, or the IPO, who is the governing body that administers and examines applications. Within a trademark application, an applicant must include 3 key pieces of information: the trademark to be registered, often a word or a logo, the goods and services that will be provided under that trademark, and the owner of the trademark, often a company or an individual. Now, choosing the correct trademark to register is vital in ensuring that you've maximized your protection. For example, word trademarks are generally the most sought after registration, given they grant a monopoly over a word or combination of words, irrespective of font or stylization. However, traders should also consider filing for other brand signs that they use. Logos, taglines are the most common alternatives. It's important to note that generic or descriptive trademarks, as I mentioned at the start of this webinar, they will struggle to achieve registration. And this is because words or signs that are generic or descriptive may likely need to be used by other traders in the same industry. And as such, allowing one trader to own a monopoly over a generic word will obviously be considered unfair. For that reason, the IPO is likely to reject an application for a trademark that is generic. And this is why it's extremely important to choose a trademark that is distinctive right from the outset. Applicants should also consider listing as many of their goods and services as possible. Now, these goods and services are grouped automatically into preset categories called classes. The more classes that an applicant includes, the more costly an application becomes. However, an applicant is essentially paying for more protection because the trademark is being registered across a number of different industries. From foregoing certain classes could result in gaps in your protection, which can obviously then be exploited by copycats. For example, if I sell cosmetics, clothing, and musical instruments, I should consider including all of these goods in my trademark application, which for reference would mean including classes 3 for cosmetics, 15 for instruments, and 25 for clothing. Now, if I neglect class 25 and I don't include it for cost reasons, for example, I'm essentially allowing another business to apply to register a similar trademark in that class that I didn't include. And I won't have, or I will have limited, registered rights for those missing goods, which is obviously not ideal. Now, if a trademark application is accepted by the IPO and no opposition or challenge is filed against that trademark application by a third party, it will then proceed to registration. Registered owners will obtain those registration rights that I talked about earlier from the date that the application is filed. Registered owners can then advertise their registration rights by placing the registered trademark symbol next to their trademark. This may ward off copycats in the marketplace and can be viewed as an attractive asset to consumers, investors, and potential buyers. Registered owners can also consider commercializing their trademark by licensing their registered rights to third parties. So what rights do I have without a trademark registration? Good question. As mentioned, you do accrue some unregistered rights in a trademark by using it. Generally, the longer that you use a trademark unregistered, the more rights you will accrue over time. As these rights strengthen as a brand develops more of a reputation in the marketplace. However, reputational rights are not guaranteed rights and can often be challenged successfully if certain strict criteria isn't met. You may also be able to rely on copyright protection in the instance you develop a brand that contains artistic elements, such as a logo. Copyright and trademarks are a little bit different. Both of them are forms of intellectual property, but trademark registrations protect brands or brand assets, whereas copyright protection protects artistic and literary works. As you can see, there's a little bit of overlap between copyright and trademarks because copyright protecting artistic works and trademarks protecting brands. Sometimes you'll have a brand that is an artistic work, such as a logo. However, in these instances, you would opt for trademark registration over copyright protection because trademark registration provides you with more solidified rights. Copyright protection is also automatic in the UK. You don't actually need to register anything to obtain rights in an artistic work. However, similar to reputational rights, these rights are often difficult to prove and enforce, and compared to those registered trademark rights. Now, attaining trademark registration for your brand name or your logo is only the first step in monopolizing and protecting your brand. Your trademark registration technically lasts indefinitely, provided you pay renewal fees every 10 years. However, there are strategies that you'll need to implement after you register your trademark to ensure that your trademark doesn't, one, share the marketplace with other infringing signs, and two, fall vulnerable to an attack by a third party. In terms of those monitoring strategies, generally, one of the most prudent things a registered owner can do is to find and take action against copycats they find online as early as possible. So this means searching social media, internet search engines, and business directories to assess whether the registered trademark is being used by another business for similar goods or services. The most common method of enforcing registered trademark rights against copycats online or in person involves sending a cease and desist letter, which I'll touch on a little later. However, you can also consider applying to take down copyright social media accounts through Facebook, Amazon, or Instagram. I note that in these instances, or in some instances, the longer a registered owner allows a copycat to use a similar trademark for similar goods or services, the more difficult it will then be to enforce your rights. For example, if I allow another trader to use a similar trademark to me for, let's say, 5 to 10 years, I'm essentially allowing them to generate their own rights in their brand. Now, you may find it's easier to search the company and trademark registers to identify copycats. So, for example, Companies House and the IPO's trademark register. Now, although on Companies House, it doesn't list all of the relevant goods and services that a copycat business will provide, the register will specify the nature of a business, and it can be a good starting point for finding that business's contact details or location, and then searching for a corresponding website. Alternatively, the trademark register will explicitly list goods and services that a copycat trader intends to provide under a similar mark. Now, in the UK specifically, you will need to object to a similar application because although the IPO may likely contact you to inform you about a later filed similar application, you need to actually take action to prevent that application from achieving registration. And as mentioned, although the IPO is going to contact you, we do generally still recommend that you monitor the trademark register to ensure that some applications don't slip through. IPO examiners are human. They do make mistakes. But more importantly, sometimes they can also have a different opinion as to what's considered similar. Now, those are monitoring strategies in terms of looking at the marketplace, looking at trademark registers and Companies House. The second thing that you'll need to do is post-registration is obviously preserve that registration itself. Now, in the first 5 years after attaining trademark registration, you technically have no obligation to actually commence using your trademark in the marketplace. However, after that 5-year mark, there is an expectation that your trademark is in use for all of the goods and services that you've listed. For example, for my cosmetics, musical instruments, and clothing classes that I listed earlier, there is an expectation I'm using my trademark for all of those listed goods. Now, in the event that my trademark is not in use, a third party is well within its rights to apply to have that registration removed, either completely or partially for some goods and services. You may also struggle to enforce your rights against copycats if your trademark isn't being used after the 5-year mark, because that copycat will simply counterclaim that your trademark should be removed from the register. The last thing that you should do when protecting and enforcing your brand is actually taking action. Now, if you come across another business using a sign that is confusingly similar to a trademark that you've registered for either the same or similar goods and services, then you are well within your rights to take action against the other business on the basis of trademark infringement. Now, your trademark registration can also be relied upon to prevent the other trademark from applying to register a similar trademark with the IPO. This latter process is called filing in opposition, which I'll now talk about. Now, being opposition savvy is key in ensuring that you retain brand monopolization. If you aren't, then another similar trademark will become registered for similar goods and services, which means you then share a portion of the trademark register and the marketplace with another similar trader. This would obviously affect the exclusivity of your rights and could lead to brand dilution and, of course, consumer confusion. Now, initiating an opposition involves filing a notice of opposition and statement of grounds, or a notice of threatened opposition, which will essentially just delay the deadline by 1 month. You should be filing the notice of opposition and statement of grounds against the other trademark application within its opposition period. The opposition period is a 2-month window following a trademark application being published by the IPO. So if you notice a similar trademark on the register, have a look at its status. The status should appear as application published, which means that that application is in its opposition period. Now, if you do not file an opposition within this 2-month window, that other trademark will achieve trademark registration. Whilst there are options available to you to invalidate that other registration, the process can obviously be a lot costlier, and the longer you wait, the more difficult this process becomes for you. So it should be noted now that opposition proceedings, they can be a long and costly process. And as such, it's worth considering contacting the other applicant to resolve the issue if you believe a resolution can be reached between the parties, or if you simply want to assert your rights. You might, for example, contact the other party and demand that they withdraw their trademark application to essentially save you the costs of filing an opposition in the first place. If you are looking to negotiate something here, a resolution that's amicable for both parties, then you should obviously ensure that you retain your fair share of the market and your registered trademark rights are not vulnerable to an attack. Now, it's important to also note that oppositions filed with the IPO will only prevent the registration of another trademark. It doesn't actually prevent its use in the marketplace. Now, in order to stop another business from actually using a similar sign to something that you've registered, you'll first need to consider sending a cease and desist notice or letter. A cease and desist letter should set out your intellectual property rights, whether you have registered trademark rights or unregistered reputational rights or copyright, for example. It should also set out examples of the other party's infringing conduct to date. It should include the claims that are available to you, which might be, for example, trademark infringement, copyright infringement, or passing off. And then it should also include specific demands within a specific time frame. Now, examples of common demands in a cease and desist letter include, for example, the cessation of all use of that brand in the marketplace, the destruction of certain materials or goods or packaging that make reference to an infringing brand, and undertakings or a written contract that promises not to engage in similar conduct in the future. If cease and desist letters are not complied with, then the registered owner may then need to consider escalating the matter to the Intellectual Property Enterprise Court or the High Court of the UK. Registered owners can also consider other avenues, such as I mentioned previously, social media takedowns to partially prevent that infringing party from using their infringing brand on popular social media sites, such as Facebook, Amazon, and Instagram. All in all, without taking that action, either on the basis of an opposition or a cease and desist letter or court proceedings, you're essentially allowing another trader to take advantage of the distinctive brand that you have created. Now that concludes the main part of this webinar, which is on protecting and enforcing your brand. You might find our Trademark Essentials Guide useful by scanning the QR code that's on the screen right now. I'll leave that up there for just a bit, just in case you're struggling to focus your phone camera on the screen. I know I do all the time. Once you've downloaded that, please just have a peruse of that guide. It obviously summarizes what I've talked about today, but has a bit more information about the trademark registration process and just trademarks generally in the UK. In terms of the upcoming event that's coming up in a few weeks' time, the next webinar that we'll be hosting is on deal structures. So this is a 101 session on understanding equity, ASAs, which are advanced subscription agreements, and convertible notes. That's on the 5th of December, so please feel free to register via the link that's on your screen right now. I will be answering your questions shortly. I can see a few questions have been submitted here. But just before I answer those questions, I'll take a minute to tell you about LegalVision's membership. So I just want to let you know our membership is a game changer. It's a game changer in the legal industry. Put simply, we are the only law firm who has successfully implemented a membership model on a global scale for legal services. So essentially, a membership with us gets you unlimited access to our full team of specialist lawyers for all your business as usual legal needs. It also includes unlimited document drafting and reviewing of business contracts. So for example, your terms and conditions, privacy policy, or any of those website documents, contracts with third parties. That's all included on an unlimited basis. You have unlimited consultations, legal advice consultations with all of our lawyers, and unlimited, most importantly, unlimited domestic trademark applications, including risk assessments, which are basically our advice on whether a trademark that you've proposed is actually registrable in the UK. It also includes discounts on quite significant member discounts on international trademark applications as well. To learn more about that membership or how we can help you, just simply request a free consultation when the survey appears at the end of this webinar, as I mentioned at the start, and we'll gladly assist you. And now I'm going to answer some of your questions. So yes, as mentioned, please feel free to submit those questions in the Q&A box. I have some here already that have been submitted. So how can I protect my brand name internationally? It's a good question. Everything that I've talked about today in terms of protecting and enforcing your brand is obviously was quite UK heavy, quite a domestic focus on everything I've chatted about. In terms of internationally, there are a few routes that are available for you to extend your trademark rights internationally. The main one is called the Madrid Protocol. So essentially, and the good thing is, a lot of countries in the world have aligned their practices and their laws when it comes to trademarks. So the Madrid Protocol is an international, think of it like an international treaty or an international trademark filing system that a lot of countries, I think it's 131 countries, have signed up to, including all of the major countries such as the US, the UK, EU as a whole, Australia, Canada, China, India, Russia, for example. They're all party to this Madrid Protocol, which essentially allows you to file one single submission and send that to the World Intellectual Property Office, who will then in turn send that through to all of the countries that you've listed on your Madrid Protocol application. So for example, if I've listed the US, the EU, and Australia, the World Intellectual Property Office, or WIPO, they will send that off to those three countries without you having to do so on a multiple basis. That's called the Madrid Protocol. So that's one way of filing internationally and extending your rights. The other way is by actually just going directly to each of those countries. So I can file a direct application in the US, file a direct application in the EU, etc. The only thing to keep in mind is you'll be filing multiple trademark applications. And some countries you actually need to use, you must use a lawyer in that country or a trademark attorney. And so as you can appreciate, the costs there will will be massive. If you're filing in, let's say, 3 to 10 countries, you're essentially paying up to 10 different law firms to file a trademark application. The good thing about the Madrid Protocol is you can engage your UK-based law firm. So, for example, LegalVision, we can file that international application from you, from the UK. You don't have to pay, 10 different law firms. You just need to pay one. Another question here is enforcement regarding passing off. So in terms of answering that question, I assume that question is, how can I enforce my rights through passing off, for example, as opposed to trademark law? I did touch on that a little bit earlier. Basically, if you don't register a trademark at all, you will essentially need to rely on passing off law to enforce your rights against copycats. Now, one thing to keep in mind is passing off requires a significant legal threshold. So what that means is, if I want to prove that someone is passing off my reputation, I need to have a reputation in the first place. And it's quite hard to establish a reputation in the UK, especially nationwide, if you're quite a small business or if you haven't been trading for very long. So if I start a brand, let's say today, and I invest into my brand significantly, I've incorporated my company, I've bought a website domain, I've set up all of my social media accounts, I've engaged with a landlord to have a lease for my business. I've got a business set up, I've got office signage, I've invested so much, I've invested tens of thousands into this business, and I start operating, I start trading. About 3 months in, I get someone who copies my brand, and I get someone who registers a trademark before me. In that particular instance, I can try and allege passing off, but because I've only been trading for 3 months, I probably don't have the required reputation to actually establish passing off. And so I'll be sending a cease and desist letter to this other side. They might just choose to ignore it, and they might send me a letter back on the basis of trademark infringement because they've actually registered the trademark and I haven't. And so all of my investments are lost, essentially, and I actually might need to consider rebranding, which is obviously heartbreaking because I was the one to have conceived the brand in the first place. So in terms of enforcement regarding passing off, just a quick mention there that we can do so. We can rely on those unregistered rights for you, but they're not very strong if you haven't been trading for a while. Another question here, what is the most cost-effective and quickest way to register trademarks, branding, etc. worldwide? I did touch on that worldwide international trademark application process. Funnily enough, the most cost-effective route is sometimes not always the quickest. So the most cost-effective would be the Madrid Protocol, which I talked about, because you're not paying, as I mentioned, up to 10 different law firms. But it's often not the quickest because it needs to go via the World Intellectual Property Office. That actually adds a few months to the application process. So the quickest way of registering a trademark would actually be to go directly to a particular trademark office itself, so file directly with the US Trademarks Office. Because you're bypassing WIPO, you're essentially saving a few months. I do want to let you know that it might be the quickest, but it's not the most cost effective. So it's up to you basically what matters most to you, time or money. Another question here, why is branding important? It's a great question. Without a brand, you essentially don't have an identity in the marketplace. Without a brand, consumers don't know you, they don't recognize you, they don't identify you, and they can't recall you if they, for example, refer you to someone else. If I have quite a generic brand, or if I don't really have a brand at all, I just call myself a barbershop. It would be quite difficult if I have quite high quality services for one of my consumers to then say, I found an amazing barbershop. They're called, well, actually, I don't know what they're called. They're called barbershop. They're about 3 stores down from the church down the street. That's not how you want to be recalled by consumers. So branding is important because it's a way of ensuring that you're identified. And therefore, it's a way of ensuring that you have return customers. You'll obviously generate a lot more profit if your consumers can recognize you and go back to you, as opposed to going to a different business with similar branding. Let me just have a quick look here to see if there are any other questions. I can't see that there are. No stress. If you do have any other questions, just please feel free to claim that complimentary consultation, as I mentioned previously. book that in, and you will have a lot more of a detailed discussion with someone in our team who can then take you through the trademark process. If you do require kind of more urgent or more, cost-effective solutions to your branding, as mentioned, I'm happy to jump on another call with you and discuss that process in detail and how we can solidify your brand in the marketplace and enforce your rights against copycats. That concludes our webinar. I hope that was useful, and have a lovely day. Thank you.